turn things over to Chris Brummer at Georgetown to take us to the next panel.
Thank you so much, Michael. Thank you, Sunea, and our entire panel. I am Chris Brummer. I'm the founder of DC's Fintech Week and the director of Georgetown's Institute of International Economic Law. That was really a fantastic conversation, and it's one that we'll be building out and developing throughout the next 4 days. Now, as we had mentioned in our announcement, we canvass the world for some of the most interesting ideas in fintech, and we wanted to bring you bring these ideas to you in very action-packed 5 to 10 minute segments to entertain and instruct, as the philosopher Rousseau said. And we called these flash presentations just that, to provide a flash of brilliance and insight. Now, before our first flash presentation, we should explain just a couple of things. Many of these expert opinions and insight come from different pockets of the ecosystem. And these ecosystem actors involve academics, but not always. And you will hear from a leading array of venture capitalists, bankers, and other market participants chiming in, as well as those working in the nonprofit community. Now, all of our papers that will be referenced in our flash presentations are going to be posted to the DC Fintech Week Brella event platform. So if you haven't signed up already, dcfintechweek.org, you register and you can access those papers. So please do check them out. For our first flash presentation of the conference, we start things off with Cryptoassets, a cost-benefit analysis of enforcement actions and securities regulation.
Hello, my name is Yuliya Guseva, and I'm a professor at Rutgers Law School. This paper is about crypto-asset capital markets. People and markets respond to incentives and change their behavior to maximize the payoffs of their actions. This is a generally accepted axiom in microeconomics. Governments enact and enforce regulations and change those payoffs. In doing so, government agencies channel market behavior towards what is hopefully productive and net beneficial actions. So, in this article, I examined whether the policies of one specific government agency, the Securities and Exchange Commission, in application to one particular segment of the market, crypto-asset capital markets, is not beneficial to market participants and efficient. In crypto, United States federal regulators operate within the framework of pre-existing pre-crypto securities and commodity regulations without reform. The SEC in particular has emerged as the leader in enforcement. In the past 3 years, the Commission has filed more enforcement actions than major foreign jurisdictions combined. The changes and penalties and SEC actions were equally more serious. Through enforcement and step guidelines, the Commission has forced crypto asset issuers and gatekeepers, such as crypto exchanges, to comply with securities law. Is this enforcement-centric approach efficient from the perspective of firms raising capital and investors in crypto securities? Unfortunately, I conclude that it does not withstand basic cost-benefit analysis and is Calder-Hicks inefficient for 2 reasons. First, DOT has propelled information disintermediation. The technology ensures information transparency and immutability. The code is often open source and viewable publicly. Smart contracts are designed to be self-executable, and organizations are autonomous and decentralized. These realities suggest that the information supplied by an intermediary, such as a traditional issuer or investment bank, is redundant from the point of view of market participants, like investors, who have direct access to data. The second reason why market participants may not receive the expected benefits from enforcement is that the current regime incentivizes issuers to avoid public placements and instead to resort to private placements. There have been only a few successful mini-public offerings to date. The obvious reasons are regulatory cost and securities law liability. Consequently, crypto issuers quite reasonably prefer private placements. Alas, private placements are built on voluntary disclosure. What does it mean? Under this approach, digital asset investors would not receive sufficient material information because issuer incentives to disclose may be weaker than those in traditional markets. A related problem is the concept of accredited investor. Accredited investors are the main participants in public and private placements. Yet this category is broad enough to include less sophisticated parties. One of the reasons is the currently imperfect proxies measuring investor sophistication. The narrative is thus complete. The SEC regulates via enforcement and ignores the significant informational component in crypto and fintech. The issuers attempting to avoid enforcement actions comply with securities law in the most rational way by resorting to private placements. In the end, the average and the less sophisticated crypto investors are exposed to the typical information asymmetry and agency costs of private placements, aggravated by the unique risks of crypto offerings. These trends undermine the economic arguments for the currently intensive enforcement of the pre-crypto rules and make the practical outcome, Calder-Hicks, inefficient. To conclude, if the Commission has opted to regulate crypto and fintech through intensive and active enforcement of the pre-crypto regulations, it at least needs to make sure that the underlying rules are efficient and net beneficial to the market and its participants. Thank you.